Before I delve deeper into the notion of constitutional supremacy, I must first say a few words on its counterpart, that is parliamentary supremacy. This is because in almost every constitutional adjudication in Malaysia, the courts are often reminded and do often themselves reiterate the words of our former erudite and revered Lord President Tun Sufyan, who in the case of Ahtian said in no uncertain terms, and I quote, "The doctrine of the supremacy of Parliament does not apply in Malaysia. Here we have a written constitution. The power of Parliament and of state legislatures in Malaysia is limited by the Constitution and they cannot make any law they please." End quote. It is important to understand, as I stated earlier, that Malaysia does not just apply the common law form of judicial administration, but we have also throughout history applied common law decisions, including English decisions. This is to no one's fault, considering that before and for many years after independence, almost all our judges at all levels were English trained and were steeped in English tradition, thinking, and ideologies. This, as will be shown later, posed a significant challenge insofar as constitutional and administrative law is concerned, because in my view, it allowed English law and ideology to creep into our legal system beyond the written words of our own federal constitution, specifically notions of parliamentary supremacy. As such, in appreciating constitutional supremacy here in Malaysia, we must first understand its diametrically opposed concept of parliamentary supremacy. In my own words, parliamentary supremacy simply means that Parliament is the ultimate constitutional authority in that nation. The most obvious and applicable example in this is the United Kingdom. The reason why I gave that brief history lesson earlier is to demonstrate that history plays a monumental role in the development of a constitution and constitutional theory. So it is important to understand how parliamentary supremacy came about in the British context, albeit in a very simplified manner. Britain was once a heavily monarchic nation where the king was considered sovereign and supreme and the source of all law and order. The king's words and edicts were law and even formed the basis of religious beliefs and customs. British kings were often influenced by aristocrats and aristocratic families. Early on, the lay folk or commoners had little influence in governance. They were mostly a workforce and a source of taxation and war resources. Eventually, aristocrats and lay people alike started to revolt, mostly due to taxation and policy differences. Over the course of centuries, the sovereign kings and even queens started to lose power to the people they governed in the formal body that became Parliament. Such an institution was a major organ to check and balance, and even in some cases regulate the acts and proclamations of the sovereign. Eventually, Parliament became the very embodiment of the people, and all other organs of state, including the monarchy, were rendered subordinate to it as the ultimate authority, even standing above the judiciary and the executive branches. That is why in the United Kingdom, it is principally the Parliament and not anyone else that is both supreme and sovereign. Parliament makes and unmakes laws even at the constitutional level. An example to illustrate how Parliament stands even above the judiciary is by reference to the old practice of its passing of Acts of Attainder. An Act of Attainder is essentially a law that Parliament can pass to legislatively convict a person for any offence without a trial. It is a means to completely bypass any judicial trial or judicial deliberation. Their existence is not imagined or fictional. You will most probably recall that during the time of King Henry VIII, an Act of Attainder was infamously passed to render one of his wives, Catherine Howard, guilty of treason for committing adultery with one Thomas Culpeper and for committing premarital affairs and punishing her with death, all without a trial, public or otherwise. This is just one of the many historical English examples. Acts of Attainder eventually fell out of favour in the United Kingdom, and by 1870, Parliament formally and effectively abolished the use of such legislation by passing the Forfeiture Act 1870. Yes, you will notice that it was Parliament that abolished its own reliance on such legislation. It was not by reason of a court decision. This methodology effectively spurred the direction of legal development in the United Kingdom. The courts there are very different in that they are also subordinate to Parliament. This is probably where the saying stems that the courts are tasked with interpreting law and not making law, which is strictly and sometimes sacredly a parliamentary prerogative. English administrative law is still influenced in this way in that judicial decisions act as checks and balance against executive power vis-a-vis challenges against legal provisions, but you do not otherwise see the English courts striking down acts of Parliament. It is simply because the constitutional theory of the United Kingdom does not recognize such a concept. The only instance, to my knowledge, where we can see such a departure is when the UK was a member of the European Court of Human Rights. At that time, Section 4, Clause 1, Section 4, Subsection 1 of the Human Rights Act 1998, itself passed by United Kingdom Parliament in ratifying the relevant treaty, allowed the English courts to pass declarations of invalidity. Such declarations, however, only declared acts of Parliament incompatible with certain international human rights instruments, but did not render such parliamentary acts or their provisions invalid or being struck down. In this sense, and putting it bluntly, rather bluntly, such declarations of invalidity only served at best as judicial suggestions to Parliament. As such, Parliament could choose not to comply, and this would render such acts legally questionable, at least at the national level. The international level is a different story. I must emphasize here that my lecture is not intended to critique or degrade parliamentary supremacy in any way. Neither am I saying that it is a dysfunctional or inapplicable constitutional modality. My point here is to highlight very briefly how it arose in United Kingdom's historical context and how it works in paving the path to the discussion on why constitutional supremacy, at least in the Malaysian setting, is poles apart. The British Empire was a powerful force that slowly dismantled over the course of centuries. The United Kingdom does not conform to Baron de Montesquieu's notion of the doctrine of separation of powers. You will notice, and I state this simply as a historical fact, that many of its former territories did not choose to adopt its form of governance but established their own political systems. Perhaps the most standout example of this is the United States of America that adopted Montesquieu's version of complete separation of powers. For the United States, not only did they adopt a written constitution, they constitutionally elected three entirely independent federal branches of government, being the executive, led by the President, Congress, and the Supreme Court. Historically, the Americans were opposed to any form of British rule or influence, that they strongly embraced notions of republicanism and direct representation in government. For the purposes of this lecture, the most notable feature of the American Constitution is the part that pertains to the US Supreme Court. I must start by stating that while the United States does not have an express supremacy clause, they have applied their constitution in that way, beginning the landmark and celebrated decision of the United States Supreme Court in Marbury. Reverting to United Kingdom for a moment, I highlighted how the courts there typically interpret legislation. They do not otherwise question the validity. That is completely not the case with the United States. In light of the igniting spark that was Marbury, we can see that the courts, or at least the United States Supreme Court, as the highest federal judicial authority, is by its constitution a co-equal branch of government that can directly and is indeed constitutionally obliged to directly check and balance the power of both Congress, the legislature, and the President, the executive. The force of the power is founded on the idea that it is the United States Constitution, a written document, that is supreme, and not any of these three arms of government, either individually or separately. The facts in Marbury are not directly relevant, but I will narrate the gist of it to prove my point. In that case, the issue was simply that the petitioner sought a writ of mandamus against the respondent, but he did this by filing a petition in the original jurisdiction of the Supreme Court. Under the United States Constitution, such a feat was not constitutionally possible, but this was made possible by an act of Congress, the Judiciary Act of 1789, that sought to enlarge the jurisdiction of the Supreme Court to grant mandamus in its original jurisdiction. The theory of Chief Justice Marshall and his Supreme Court was quite simply that while the petitioner was on the facts entitled to mandamus, he ought not to have filed it in the Supreme Court's original jurisdiction. The Judiciary Act of 1789, which purported to enact legislation to enlarge the Supreme Court's legislation against the United States Constitution, was declared void and invalid. And thus, while Marbury was entitled to the mandamus on the facts, it was effectively deemed illegal to have granted it to him by virtue of the fact that the United States Supreme Court did not have jurisdiction to grant it. By such a ruling, the Supreme Court directly and effectively declared that the US Constitution is supreme, and any law that is passed by Congress in violation of it is liable to be struck down. I can do no better than quote Chief Justice Marshall as follows. So, if a law be in opposition to the Constitution, if both the law and the Constitution apply to a particular case, so that the court must either decide that case conformably to the law, disregarding the Constitution, or conformably to the Constitution, disregarding the law, the court must determine which of these conflicting rules governs the case. This is of the very essence of judicial duty. If then the courts are to regard the Constitution, and the Constitution is superior to any ordinary act of the legislature, the Constitution and not such ordinary act must govern the case to which they both apply. Those then who controvert the principle that the Constitution is to be considered in court as a paramount law are reduced to the necessity of maintaining that courts must close their eyes on the Constitution and see only the law. This doctrine would subvert the very foundation of all written constitutions. It would declare that an act which, according to the principles and theory of our government, is entirely void, is yet in practice completely obligatory. It would declare that if the legislature shall do what is expressly forbidden, such act, notwithstanding the express prohibition, is in reality effectual. It would be giving to the legislature a practical and real omnipotence with the same breath which professes to restrict their powers within narrow limits. It is prescribing limits and declaring that those limits may be passed at pleasure." End quote. The Marbury decision, a powerful one, particularly because it was unanimous, is widely regarded throughout history as establishing judicial review. I cannot emphasize enough that Marbury was decided within the context of the US Constitution absent an express supremacy clause. Marbury is the first rational step in my constitutional analysis because it is the first emphatic judicial decision that established a precedent for when an independent judicial arm of government may effectively annul and defy a statute passed by a democratically elected body.